So what I've tried to do is I've tried to focus on asking the questions of when is it worth it? Because in reality, summary judgment isn't always worth it. Albeit hopefully by the end of this talk, and certainly after I'd read some of the more recent cases in the High Court this year, I was certainly left thinking, actually, there may be more scope for summary judgment than we otherwise might think or give advice to our clients on. So we're going to start with, first of all, a little bit of easy introduction, some of the basic principles when it comes to summary judgment. And then I've chosen 3 cases, which are all recent cases from this year in the High Court, each of which I think has a little nugget of assistance, hopefully, in any event, for you all to take away with you. So starting with the easy stuff, what is summary judgment? Well, let's look at CPR Part 24. And the reality is that we start off by looking at what can we get summary judgment in relation to. And the first point I want to make is you can get summary judgment in relation to an issue. An issue is something distinct from simply a claim or a defense. But you cannot get a summary judgment on an issue if it's not going to make any difference to the final hearing, other than there's simply one less thing to deal with. You can't get summary judgment, or the court has no power to give summary judgment in cases for unspecified amounts of damages. You can have CPR Part 24 applications, not just on claims, but on all Part 20 claims. That includes counterclaims, it includes additional claims, for example, for contribution or indemnity. It applies to all such claims. In terms of CPR Rule 24.2, what kind of claims can you not bring summary judgment in relation to? And it's quite important to remember this, because under 24.2, you cannot bring summary judgment against a defendant in any type of case which relates to, for example, proceedings in possession of residential premises or similar. I don't know yet if I've seen, thankfully, an application where someone's tried that, but a polite reminder, you can't get summary judgment in those cases. 24.3, which is the next and probably most important rule you need to know when it comes to summary judgment applications. Now, this is a well-rehearsed test. It is a test with which you will all be familiar, but it bears repeating. You can get summary judgment if there is no real prospect of succeeding on the claim, defense, or issue. Remember what I said about issue before. And there is no other compelling reason as to why the case should be disposed of at trial. It is important to remember that you need to satisfy both of those limbs if you're going to be able to bring a successful application for summary judgment. And the burden is always on any applicant in order to establish that those grounds are made. One point I do think is worth remembering is this. There is an evidential burden on a respondent to an application. So if you bring an application and you've got good basis for it in your application, then the respondent is at least, I say, evidentially at least, has a burden to bring some evidence in reply. So if you're acting for defendants, you need to get your house in order and get the evidence together. The difficulty in practical terms with these applications can be that they're often brought, as they should be, in more cases than not, early doors. So it can really front load your client's costs, it can really front load your work. And what it can also do is it can also make you show your hand early, which has its upsides, but likewise it has its downsides, because sometimes you wish to sit with your cards close to your chest. But this application tactically can flush that out from a very early stage. That might be particularly useful, for example, if you've got a party against whom you're bringing a claim who hasn't been very clear so far, or they haven't really engaged at all, and they're not giving you much by way of disclosure. This might be the kind of application you might think about making to flush that out. One thing which is important, and you do hear this regularly, I think, in response to summary judgment applications, is, but we're going to have loads of evidence at trial. You know, we need disclosure. The disclosure is all going to come out, and this is all going to, fix our case and plug all the holes in our case, and it's going to fix the sinking ship. Be very wary of that if you're the applicant, because respondents should be substantiating any such assertion by giving at least something in witness evidence to explain what they say is going to exist, first of all, why it's reasonably going to exist in the future, and importantly, what difference is it going to make? That's an important point, because people can say there's lots going to come out, but what reasonably is it going to do to the outcome of the trial? And if the answer to that question is nothing, then you're on solid ground as an applicant in rebutting any such assertion. The important point, or the important case, if you haven't read this case, then you absolutely need to, is the Easy Air Limited and Opel Telecom case. It means something which is more than just a prospect. It needs to be a realistic prospect, certainly something more than fanciful. It needs to be more than arguable. It needs to be reasonably arguable. And you need to be able to win on the application without there being a mini trial. I'm going to ask you to remember that when we come to some of the authorities which I've picked from this year, because to my mind, there may be a bit of a tension between what we're told not to do, which is to bring an application involving a mini trial, and then looking at what the High Court has done in a couple of the cases this year at least. You must look at the evidence reasonably expected, and it does give us guidance here that, and again, I'm going to ask you to remember this when we look at the cases from this year, that there may be cases, for example, where there's a short point of law. The best point I can think of is where there's a short construction of a contract term or an unpaid debt claim, for example, where you've quite obviously done the work, you've issued your invoices, and you've got some litigant in person on the other side who's spuriously telling you that they can't pay, they shouldn't pay, and they've got no money to pay. This is the kind of case where one expects summary judgment to be more fruitful, but there are others. And finally, just a general point is beware of the defendant or the respondent who tries to make it sound much more complicated than it actually is. And you do get this because I remember, I think even at bar school, part of the advice we were given many years ago now, was for a claimant, make it straightforward, simple, don't say much in your witness statement. If you're responding to an application, chuck everything in, chuck in the kitchen sink, the cat, the dog, and everything with it, because you need to try and throw up the smoke screens to make it show a judge that actually this is really complicated, you can't possibly deal with this now, you need to get this off to trial. As I think we're probably going to see, judges aren't stupid, and they will see straight through it. So before we look at those compelling reasons, I confess, I tried to get you some really good guidance on what was a compelling reason for something to go to trial. And I'm going to equally confess, I couldn't find anything. The real way to explain, for example, in the White Book commentary is by example, rather than giving you a definition or some other guidance as to what compelling means and to what extent you need to say this needs to go to trial. So I'm not going to go through them, but I've picked out some of the examples I could find from the commentary in the White Book. And it seems to me that, sadly, I'm not in a position to really give you any much better guidance, but it's room for argument is the point I'm making. Certainly if you are responding to an application, but if you're a claimant, you might want to think, or an applicant, you might want to think, well, hang on a second, let's think carefully, why might this need to go to trial? Is there something which is unusual about this? Is there a public interest in this, for example? Does this have wider ramifications which need this to go to trial? Those are all the sorts of things you need to be thinking about when you're thinking about making an application for summary judgment. Now, what I do now is I've chosen 3 cases from this year. So I've tried to do it as an update, and I've also tried to pick out, when I read the cases, some, I think, important examples from those cases to try and see if there are any lessons to be learned as to when we should and we shouldn't be bringing summary judgment applications. And the first one, and I'll be honest, the most interesting one I found was this one, Gerasimenko and others against VTB Capital PLC in administration. So this wasn't a straightforward standard case, it was complex, it had lots of issues. The value of the claim was $800 million worth of a fraud claim. In this case, the claimants were former owners of what was called a Red October Steelworks in Volgograd. They claimed that their interest in the works had been wrongly expropriated. Conspiracy was alleged in the case, so we have a really serious, complicated cause of action, which is pleaded. And it included that VTB, which was a Russian bank, was one of the co-conspirators in the case. And it was alleged that there'd been some false criminal charges brought against the claimant, Mr. Gerasimenko. Where VTB Capital Limited came in, they were a London rather than a Russian-based firm. They were a subsidiary of the main Russian bank, and they were ultimately what was described as the anchor defendant, i.e. they were the person, they were the body, they were the party based in the jurisdiction of England and Wales, which allowed this claim to be brought at all in the first instance in the courts, the high courts of England and Wales. And in this case, set against that very brief background, VTBC brought a summary judgment application as a defendant. So they brought a reverse summary judgment application against the claimant. And they ultimately said no basis for these claims. And as a result, our courts do not have jurisdiction to hear this case, because once the English party goes, so does the claim with it. All the usual points were argued: mini trial, this is highly complex, it's factual, you need to send this off to trial. There's Russian experts in the case, there's Russian law, there's an international element to all of this. So on the face of it, to me, this case had all the hallmarks of a complex, difficult, perhaps trial-worthy case. You might sit in the room and think, not the kind of case you might have advised to make a summary judgment application in relation to. I'm not sure that when you look at the facts, it cries out as being a summary judgment application, because, as I say, it had all the hallmarks of something serious and complex. The High Court grappled with it. And if you read the judgment and you read the decision, the High Court really wasn't fearful of getting to the heart of every single point that was being made, and wasn't fearful of the fact that there was complexity to this. I think everyone recognized there was complexity to this. But the High Court, in a really detailed judgment, goes through analysis by analysis, point by point, why this application is a good application. But I thought the pithy conclusion, which I've summarized at 31, did the job, because the claimants emphasized that at the present stage, information available is limited, and it is to be expected more will be available after disclosure and a trial. And I should not conduct a mini trial on complex materials. And here's the best bit, I thought. But the problem is that the material before the court and that relied on the claimants does not make any sort of case against VTBC, i.e. you have literally zero. So I said to you earlier, be wary of the defendants who make it sound complex. Be wary of the defendants who make it sound like there's a lot of bluff and bluster going on, which really doesn't make any difference to the case at all, and get stuck in. It didn't feel like a case that was ripe for summary judgment. But if you say paragraph 35, it seems to me that it does give us some tips as to when it might actually be worth it making a summary judgment application. And no doubt in this case that the judge probably had in mind the fact that if the application succeeded, this claim was gone forever out of our courts of England and Wales, because it was only there by reason of this one very defendant. That probably also meant it made it worth making the application at all, because the fruits were worth the pursuit of this application. But it also points out certain elements where, have a think and look carefully, where there is no evidence as opposed to merely scant or possible evidence. In this case, I think it's right for me to point out, but you will all have seen this, there was a grave inconsistency in the way that the claimant had pursued their case. In fact, I think at the hearing, they all but abandoned their originally pleaded case in favor of trying to run another case entirely. But just be mindful, because how many of us in this room will have seen parties ever-changing causes of action, ever-changing pleadings, and ever-changing cases? Thirdly, the judge in this case, and again, general point worthy of mention, there wasn't any prospect of a disclosure exercise filling in the blanks. So when you've got someone saying to you, yeah, okay, disclosure is going to fill the blanks, what disclosure? Tell us what disclosure you say is going to come out of this, which is going to change any of the result. And as I make the point, it was worth it in my view in any event, because of the fruits that it bore. It got rid of the entire case out of the country. So the second authority, which I've picked from this year, and these are more good examples, I say, than authorities giving us a new point of principle, but we can learn lessons from these cases, is the case of Vanquis Bank Limited and TMS Legal Limited. This is a case where the defendant specialized in financial mis-selling claims for consumers, in irresponsible lending claims against lenders. And one such lender in this case was the claimant. And you might think unusually, because it didn't strike me as an obvious claim to be bringing against the firm of solicitors who've made a claim against you through their clients or for their clients. But they brought a cause of action which was causing loss by unlawful means. Now, again, on the face of it, it's an unusual one, because it's not one I think I might have thought of when they were trying to bring a claim against solicitors who'd supported claimants bringing claims against them. But 39 tells you what the cause of action requires, and you'll all know this, no doubt. It requires unlawful acts, independently actionable by a third party. It requires interference with the actions of the third party in which the claimant had an economic interest. An intention, and we're going to come back to the question of intention in the context of summary judgment, to cause loss to the claimant by the use of unlawful means, and 4, loss in fact was caused to the claimant. So in this case, this was again another reverse summary judgment application where TMS applied to strike out the claim for get summary judgment on numerous bases, and ultimately they argued. And again, if you read the judgment, they made a submission on quite literally every single part of the torts test. So the judge, when you read the judgment, goes painstakingly through each limb of the cause of action, telling everyone and telling the defendant why their application in this case wasn't successful. But the reason it's relevant, I think, is threefold. One, it is another good example of the High Court to set out limb by limb why the summary judgment application failed. But the two main points I think come out of it are these, and which I think are really worthy of consideration, is first of all, the question of intent. And I'm going to include in that, for example, causes of action which include dishonesty, or if there needs to be a requisite mens rea in order for the claim to succeed. You'll see paragraph 44, the judge in this case said, "In my judgment, whether TMS possessed this requisite high level of knowledge and intent can only be proven as a matter of inference and would depend in part on how its witnesses were cross-examined at trial. They would be unlikely to admit it. In my judgment, it is at least a possible inference that the masterminds of this economic model did possess the requisite degree of knowledge and intent." So I pause there and I make this point. Is it worth bringing a summary judgment application in cases where there is a required mens rea, so an intent or a dishonesty? Or are you on a hiding to nothing, as they say, because all of that needs to go to trial for the relevant witnesses to be cross-examined and for there to be a proper challenge on the evidence before anyone can actually determine whether or not there are reasonable prospects of success in any claim? Well, the answer to that, I think, is yes. One definitely should be more cautious, and I think it's a much harder job, for example, for claimants making applications against defendants for summary judgment. There might be more to gain from defendants making summary judgments against claimants where they're having claims of dishonesty, whether it be deceit or otherwise, brought against them. Because if there really is little to bear in terms of the evidence, and there's not going to be anything, then defendants, I think, are more likely to succeed than claimants would in the opposite direction. And the second important point is this, and I think you can take away from this, is that if your application is premised upon, well, the claimant can't prove any loss, or they're not going to prove to you that there's causation of loss, then I think a summary judgment application probably in most cases is not worth it. And really that's what was going on in this decision in the High Court, because it was ultimately said, well, you know, a matter of loss, it is a matter of evidence. You can't really say at this stage on earth, how on earth are you going to say at this stage? They're not going to be able to prove that they've suffered a loss and that there's causation. I think the only real example I can think of as to when it might be worth it to bring a summary judgment application based on causation and loss is if, for example, you do see litigants in person in particular doing this. People bring claims where they try to recover a loss which, as a matter of law, simply does not work, and they cannot bring a claim for that particular head of loss. So in those circumstances, of course, it's worth it. But in other circumstances, I would suggest it's not. The third and the last case, which I've brought up, is a case of Gupta and Shah. And again, this is another High Court case. And I'm not going to go into the detail of the facts in this case, but it's the one which had a bit of a sorry history, and there seemed to be application after application being brought. But again, it's a case in which the claims were not uncomplicated. There were claims of deceit, conspiracy, dishonest assistance, knowing receipt, and unjust enrichment that were brought against the defendants. And again, in that case, the reason I highlight it is because what was rather unusual about this is that this was an application brought after there had been disclosure. Now, that is rather different because summary judgment applications tend to, as a matter of rule, be better done and made earlier in the course of proceedings for obvious reasons. One, saving costs. Two, just get rid of a long trial. We don't want to go through all of this. The stress, the hassle, the reputational risk that comes with all of that. Flushing out, as I said earlier, trying to flush out someone's position at an early stage And we're all encouraged, are we not, to act proportionately in line with the overriding objective. So bringing early tends to be the way forward. But in this case, the application came after disclosure. Now, it plainly worked, and it was plainly worth it in that case because the application succeeded. And the complicated case, as it looked on its face for conspiracy, etc., with the intention and all the other hallmarks that are needed, was given summary judgment against it. But the reason I highlight this is because if you go through a disclosure exercise and you've got a trial in about 6 months' time, which is going to be 10 days long, and you're going to spend goodness knows how much getting it to trial and having your very expensive barristers, no doubt, turning up to trial to represent you, but you've got the disclosure and you really think, having reviewed that disclosure, there is not a shred in this, and you'd have to be pretty confident. It's pretty bolshy to do it, but it can work. So if you've got the time and the inclination, and by that I mean what's the reward you're going to get from making this application, then actually sometimes it can be worth making the application even after disclosure if you're going to save time, cost, and effort. So those are the 3 cases I wanted to take you through, but I just wanted to, I think it was wrong of me not to at least highlight some of the specific restrictions within Part 24 as to when it's really not worth it and when you can't bring an application for summary judgment. And if you see paragraph 53, I've set out the contents of Rule 24.4, and I'm not going to go through those in any real detail, other than to tell you that you ultimately need to know what 24.4 says, and you need to remember not to fall into the trap of bringing a summary judgment application where one of those points applies. 24.5 is more procedural, and really there's only one point I want to highlight in this. Well, there's 2 actually. It's very prescriptive as to what your application needs to say. If you're not going to say those things, don't bother bringing the application because it won't be worth it, because you'll have a judge saying to you, well, you've not complied with CPR Part 24, and the worst case scenario is they could dismiss it. They might be lenient, they might give you a little bit of leeway and say, oh, it's not, not to worry, I'll abridge or I'll override, and I'll allow that failure to not cause a problem. But the big one, which I just wanted to make a point of, is drawing the respondent to the application's attention to the fact they have the right to rely on evidence in opposition. Now, this may sound very easy and it may sound very obvious, but the number of applications you see which do not do this, and you do get judges pulling you up on this, and you do get judges saying to you, why haven't you done this? And it can cause you a problem. For example, if you're against a litigant in person who hasn't filed any evidence and you've not told that person that they can file evidence, wouldn't surprise me too much if you have a judge who says, well, I've got someone here who wants to bring evidence, we're going to adjourn this, and actually it's your beef, it's your problem, because you didn't tell them that they could bring evidence, and had you done that, they would have done, and we wouldn't have been sat here wasting our time and costs at this summary judgment application hearing. That and your draft order, again, pretty straightforward stuff, but my big argument or my big point here is don't forget, please don't forget, because it can be fatal. We're at the conclusion stage, and what I've tried to do in the conclusion is to come back to the theme I started with, which is, I am going to say don't be frightened, don't be scared of making summary judgment applications. I'm not suggesting for a second we should be frivolous in the making of summary judgment applications. Of course I'm not. There will be many cases where it's simply, to answer the question, isn't worth bringing a summary judgment application. But the point I really do want to walk away with, and again, I confess, I walked away with it when I did this review in preparation for this talk, was I think there are more cases out there that could be ripe for summary judgment applications than I would have otherwise thought of in the last 16 years. You might have otherwise thought of, and we're all fearful of the it's a mini trial point. So take a look at those cases, because I think they might fill you with a bit more confidence. And what I've done in practical terms, you'll see I've given a list of what I think are some really useful pointers for you and your client to be thinking about if you're thinking about bringing a summary judgment application. How much of the claim will I get rid of? Is it a neat, straightforward point? Is it a debt or is it a contract point? Will the determination of this clause in the contract rid of this claim? Or might it rid of this claim? Might it make your life easier in terms of settling the claim if it were to go in your favor, for example? Does it involve the need for disclosure, expert evidence? Strikes me that if you've got a case that might need expert evidence, you might be in more sticky territory getting summary judgment. The timing of it, earlier is better, quite accept that, but don't be fearful. Even if you think you've got a good point after disclosure, don't be frightened to make it if need be. And ultimately, what are you going to gain out of this in terms of costs and tactical advantage? Because I keep on saying this, but it is right. You can gain a tactical advantage. You can also lose one because you've got to show your hand a bit early doors. But if you're not frightened to do that, you could stand to gain by finding out what the defendant's position is or the respondent's position is early doors, which could do everyone a favour in helping narrow the issues at least and helping you get to a more successful conclusion for your clients. So that, in a nutshell, is summary judgment and when it's worth it.